Hey, Ms. Bridgewater.
How are you?
Hey, good afternoon. Did you get the email about the case for Dwayne James? We got a case number, but he's not on the calendar.
No, I did not.
Let's see if the jail can bring him down so we can address it. Can we get that added onto the calendar?
That means that the public defenders wouldn't have had time to interview.
Yes, I actually interviewed James.
Yes, Miss Bridgewater, he was on the jail pull sheet. I do not know why he did not get added to the actual list, the SEA calendar, but he was in fact on the jail pull sheet and probably is in the jail courtroom.
Okay, well, with that being said, and he's been interviewed, I don't see why not.
Okay, thank you, ma'am.
You're welcome. And Mr. Abdullah, did you see where I acknowledged the receipt of that null pros?
Yes, ma'am, and I appreciate your acknowledgement. It's always good to know you received it.
My pleasure.
Thank you.
Bye-bye.
All right, the time is 2 p.m. Let's get started. This is the State Expedited Accusations calendar. I am Judge Melanie Williams. Today is February the 8th of 2023. At this calendar, we will address cases that have already been formally accused by the Solicitor General's office, even though the individuals have only been recently arrested. All defendants, you have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney at this proceeding. When I ask you if you understand your rights, those are the rights to which I am referring. All participants, this particular proceeding is being broadcast over the internet. It's also being recorded. That means any member of the public can log on and watch this. Ms. Bridgewater, you said that there was a null pros for one of the cases on the calendar today?
Yes, position number 13.
All right, wonderful. So we will not address that. And I'm understanding that there is an add-on position as well. So
Yes.
At some point, if someone can maybe perhaps put the case number in the chat if we're going to address that case. Ms. Bridgewater, what is my reset date?
February the 21st.
All right, so those who receive a signature bond will be reset for the notice. Those who receive a surety or cash bond will be reset to the state all-purpose calendar on February the 21st, whereby bond and other conditions can be addressed at that time. All right, who do we have first at the jail?
Good afternoon, Judge. This is going to be position 3, Ms. Davis, and she also has her mother in the gallery.
All right, thank you, Ms. Davis. Your case number is 23 CR 778C. You're charged with simple battery against a public school system employee, 2 count, with the offense date of February the 7th. Do you understand your rights?
Yes.
All right. This is her first arrest, so we'll go straight to the state. Whose case is this for the state?
This is my case, Your Honor. My apologies.
All right, Ms. Dillingham, please proceed.
Yes, Your Honor. This incident occurred February 5th, 2023, where officers responded to the victim Terrence Neesmith's residence located at 5671 Laurel Ridge Way. Your Honor, one moment, Your Honor. I believe I might have the wrong date this.
Yeah, this is position 3.
Okay, 1 second.
Trinicia Davis.
Right, and that incident date didn't match as well.
Right, my apologies, Your Honor. I just beg the court's indulgence. Okay, I had 2 of my cases mixed up. My apologies. This incident occurred yesterday, February 7th, 2023, where officers responded to North Metro GNETS, which is located at 601 Beckwith Street. The defendant is a student there, and yesterday the defendant threw milk on the first victim, DeQuentin Roberts, who is a teacher at that location, before punching him in the chest multiple times with closed fists. Then the administrative staff of the school put the defendant into a mindset restraint to calm her down. And after being released from said restraint, the defendant punched and kicked the other victim in this case, Miss Ramona Hicks, who was also a teacher at the school. Our victim advocate did speak with both victims, in addition to the principal of the school, who informed us that this was not the defendant's first violent interaction with a teacher at the school, and that as a result of this incident, the defendant has been suspended for 4 days. Your Honor, the school also informed us that they're in a process of what they call a manifestation hearing. So they will determine after the 4 days whether or not the defendant is able to come back to the school. So for that reason, the state is recommending a $4,000 surety bond, $2,000 on each count. And a stay away order from the school for the 4-day suspension. And if it's said that she is not able to come back to the school, we would ask for a stay away throughout course of probation, and no further contact with either victim, DeQuinton Roberts or Ramona Hicks.
All right, thank you. Before I go to that, I see an Anitra Raby on the Zoom conference. Ms. Raby, if you are here for Maisha Raby, that case has been dismissed. So I believe that, is that correct? Is that position 13? That's the no
Yes,
cross?
it has been no cross.
Right, so you're free to go. That case is no longer holding Miss Maisha Raby in the Fulton County Jail, okay?
Okay, I have a question.
I may not be the best person to answer.
Okay,
The best
okay.
person to contact is her attorney, all right?
Okay, gotcha.
Call me
Okay.
later, please.
Thank you.
Right,
Please
thank you.
give her attorney a call. All right, thank you.
And Your Honor, if I may, the victims are on the line and we would ask to sound for them.
Okay, all right, at this time, I'm sounding for Mr. Roberts. Mr. Roberts, if you're present on this Zoom conference and wish to make a statement, this is your opportunity to do so. If you wish to, you're not required to. Would you like to make a statement?
No, I think I agree with the recommendations from the.
Okay, just yes or no first. I would have to place you under oath if you want to say anything else. So no statement?
No.
All right, thank you. Ms. Hicks, would you like to make a statement?
No, ma'am.
All right, thank you so much. I appreciate you both for coming to court today. All right, who represents Ms. Davis?
I do.
All right, please proceed, Ms. Holly.
Yes, good afternoon, Judge. So Miss Davis is 18. She just turned 18 3 days ago. She lives with her grandmother and she does have a 3-month-old child, Jelani, who she cares for. She is currently a student, and as far as I can tell, she's still currently enrolled at the school. I understand the 4-day suspension. She is currently set to graduate in May. Obviously, she is not admitting to any of the violations, and I do believe that there is additional information that has to do with this incident. I would just ask the court to consider the fact that she does not work. She lives with her grandmother and she has a small child who she cares for. This is her first arrest. She's never been arrested before and she is quite young. We would ask the court to take all of that into consideration, grant her a signature bond due to the fact that it is a first arrest. In addition to that, I would ask the court to consider and further explain what the stay away order would look like. Obviously, if she is allowed back to the school, which hopefully she is so she can graduate, I would be concerned about a no further contact order if it's not specifically outlined, because she would be at the school as with these teachers, and I don't want her to be in violation of the conditions while she's there. Obviously the stay away during the course of the suspension, where we have no issue with that, we would just ask that if the suspension turns into something more, that the state be able to revisit that to modify the bond conditions as necessary.
All right.
And Your Honor, the principal of the school is actually on the line as well, Miss Najma Hunter, and she may be able to shed some light towards that stay away order.
I am.
Wait, one second.
Can you unmute?
Is the
Thank
state
you.
requesting
Yes.
a curfew for Ms. Davis?
The state would also request a curfew from 8 p.m. to 6 a.m., Your Honor.
I did want to make one correction. I heard.
One second, Ms. Hunter.
Okay.
1 second. Thank you. All right. Now, the next question that I had is, what grade is Ms. Davis alleged to be in?
She's in
She's a
12.
senior? Okay. And does she work as well?
She does not work. She cares for her child when she's not in school.
Okay. All right, Ms. Hunter, I will hear from you briefly. I will have to swear you in. Please, will you please raise your right hand?
Yes.
Will you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what would you like to tell me at this time?
Yes, I was trying to fact check the accuracy of her being a senior. She was a sophomore. I know she's not slated to graduate this year. Regards to the restrictions, she does have a pension. And specifically for students, I don't know if you guys are familiar with North Metro GNETs, but all of the program have an IEP. And specifically for Trinicia, for this infraction, she does have 4 days of out of school suspension related to that. And I did share with the solicitor that we are scheduled to have a manifestation meeting on the 14th at 1 o'clock. And during that meeting, we will talk about if that particular infraction is related to her disability. We also will have a tribunal hearing. So I can't really address or say if actually end up, still being at receiving education, at North Metro GNETs, or if it will specifically be school setting. I did hear, and I know that Mr. Roberts as well as Ms. Hicks, they were not sworn in and they elected not to make a statement. I know prior to me logging in, they had shared that they had some safety concerns and reservations in regards to Trinicia returning back to school because they did feel, threatened. They felt that they
Okay, Ms. Hunter, I understand that this is not an evidentiary hearing. Really what I'm most concerned with, you did inform me that you're not clear with whether she would come back. I guess my only question is, if I do order the no contact whatsoever with those teachers, would your school be able to accommodate that?
No.
Okay. So those are the only two, the court is inclined to find that she is to have no contact with those teachers. And you're telling me, Ms. Hunter, there's absolutely no way to work around that provision? There's no other?
No, we have
educators?
3 teachers at the high school level, Mr. Roberts as well as Ms. Hicks.
Okay, that cannot, okay, I understand. Thank you, Ms. Hunter.
You're
Is there
welcome.
anything else that you'd like to make me aware of
No.
at this time? All right. All right, in light of the testimony that I've allowed to have to be admitted today, is there anything further from the state of the defense?
Nothing further from the state, Your Honor.
Anything?
Your Honor, we would just ask, I understand that there have been allegations made of additional fear, but we would just ask the court to consider that this is still her first arrest, and there haven't been any other legal accusations levied against her prior to this incident.
All right. All right, at this time, Mr. Howard, is she gonna, if I do decide to send this through pretrial, even though she's 18, would you require a co-signer?
Yeah, she's still in school. Then they said she was like in the 10th grade or something.
She's 18. So the answer is yes, the co-signer will be required.
Yes.
All right.
And I believe it was said that her grandmother is on the Zoom.
All right, well, the grandmother's not the victim in this case, so we're gonna not hear from her family at this time. All right, what we're gonna do is I'm gonna give the defendant a split bond because I do want her to take the 1-day anger awareness course that will go through pretrial. So of course it's gonna go per judge. On the first count of simple battery against a public school employee, that's gonna be $1,000 surety bond. Then defendant's gonna receive a $3,000 signature bond through pretrial services per judge. She's to take the 1-day anger awareness course. And during the pendency of her suspension, she's to have no contact whatsoever, no via social media, phone contact at the school with the alleged victims, in this case, last name Roberts. And I believe the other last name was, what was the other last name?
Hicks, Hicks.
Ms. Hicks, to have no contact whatsoever with them. If she is permitted to return to the school, then no further contact would not apply because I've been informed that that would not be possible During the pendency of that, the tribunal's decision will control her ability to return to that location. Additionally, despite her age, she used to have no alcohol, drugs, or weapons. Ms. Holly, do you know the name of her grandmother or her mother who
I
will
do.
be the co-signer?
Please hold, I can give you the name of the grandmother. Her mother is not,
Judge, we have the mother here that's gonna sign, co-sign for her.
What's your name? Did she say Angela Walker?
That is correct.
That's correct.
All right, that is the name, Mr. Howard, and I will waive utility bill if you send me the form. All right, is there anything additional from either the state or the defense as it pertains to this case?
no, Judge, for the state.
All right, best of luck to you, Ms. Davis. That concludes your case at this time. All right, who do we have next?
Position 14, Sharp.
All right, good afternoon, Ms. Sharp. Your case is 23 CR 0000785. You're charged with battery family violence with the offense date of February the 7th. Do you understand your rights?
Yes, ma'am.
All right, can I have the history, Mr. Howard?
Second arrest, 2018 DUI.
All right, thank you. Mr. Abdullah, please proceed.
Yes, Your Honor. The facts show that on February the 7th, 2023, officers were called to 1310 Lando Lakes Drive for a domestic disturbance. Upon arrival, they met with the defendant, who told them her and Mr. Marks, Mr. Peter Marks, which is the victim, and her boyfriend were arguing about her drinking habit. The defendant told officers it was only verbal. However, Mr. Marks was present, and officers observed scratches and swelling on his left arm, as well as scratches on his face. Mr. Marks told officers while the two of them were arguing, the defendant hit him multiple times. If we could sound for the victim, he may be on the Zoom.
All right, what's your recommendation for the bond amount?
No, the state is recommending $2,500, $2,500 surety bond, no further contact with the victim, stay away from the incident location, no weapons, drugs, or alcohol while on bond, and a 1-day anger management.
All right,
Or
thank
anger
you.
awareness.
I'm gonna sound for Ms. Marks at this time, Mr. Marks at this time. If you're present on the Zoom conference and wish to make a statement, this is your opportunity to do so. All right, hearing none. Who represents this defendant? Is it you, Ms. Watson Cafe?
Yes, Your Honor.
Good to see you.
How are you?
Please proceed.
Yes, Your Honor. We will be asking for a signature bond in this matter. As you heard, the defendant only has one prior arrest for DUI. It wasn't a violent offense. She's a lifelong resident here in Georgia. She has significant ties to the community. She runs her own real estate business. I just don't see a reason why there would need to be a surety bond on this. I think there's nothing in her history that would indicate that she would not show up for court, and I believe that a signature bond in this matter would be appropriate. As you're well aware, Your Honor, she's presumed innocent at this stage. We vehemently deny the allegations that are contained in the police affidavit, and so for all those reasons, Your Honor, I don't believe that there's any reason why a signature bond would not be sufficient in this case.
All right. At this time, defendant will receive a $3,500 signature bond per judge through pretrial services. She's to take the 1-day anger awareness course, have no contact with the alleged victim, and stay away from the address on Lando Lakes Drive. She can return one time with a member of law enforcement to get any items that she may need to collect from that location. Is there anything further?
No, I just want to inquire. I'm sorry, Your Honor. I should have done this before. Ms. Sharp, is that the location that you shared with him?
Yes.
Okay, and you have somewhere, you understand that you can only return one time to get your stuff. You have to go somewhere else, from one of your family members?
Yes.
Okay. That was all, Your Honor. Thank you. And I don't have any, I have 3 other clients, but I don't have anything more for this client, Your Honor.
All right, thank you. Best of luck to you, Ms. Sharp. That concludes your hearing. Who do we have next?
Position 4, Duffy.
All right, good afternoon. Ms. Duffy, your case is 23 CR 000 792Y. You're charged with battery, family violence, and 2 counts of cruelty to children in the 3rd degree with the offense date of February the 5th. You understand your rights?
Yes, ma'am.
Thank you, Mr. Howard.
The third arrest. 2019 battery DV out of East Point. She had a 2014 out of South Carolina, reckless driving, possession of marijuana. And those were convictions. The battery case that's open, that's 22 CR 002 498Y as in yellow. That's it.
All right, thank you. Ms. Dillingham?
Yes, Your Honor. This incident occurred February 5th, 2023, when officers responded to the victim Terrence Neesmith's residence located at 5671 Laurel Ridge Way. There, they learned that the defendant and Mr. Neesmith were in a verbal argument. And to prevent the argument from escalating, Mr. Neesmith had attempted to exit the room, to which the defendant prevented him from doing so by hitting him several times, causing visible scratches to his neck that the officers observed upon arrival. And all of this was done in front of their children, their 2-year-old son and their 5-year-old daughter. And Your Honor, because of the previous history involving a battery arrest, we do have concerns regarding Mr. Neesmith's safety and regarding the stability in the home. So for that reason, the state is going to recommend a $5,000 surety bond, $2,000 on the battery, and $1,500 on each cruelty charge. A stay away order from that address, 5671 Laurel Ridge Way. No further contact with Terrence Neesmith, and then third-party transfer of the children. For the purposes of this hearing, I'll give their initials TN and TP. I do believe the victim may be on the Zoom, and if so, we would ask to sound for him.
All right, I'm sounding for Mr. Neesmith at this time. If you're present on the Zoom conference and wish to make a statement. Okay, seeing and hearing none. Ms. Watson Cafe, is this your case?
Yes, Your Honor. Thank you.
All right, please proceed.
As an additional matter, we would ask that there not be a stay away issue. This is actually her home that she shares with her mother. So if anything, this would be a situation where he, I understand that he's not here, but this should not be a situation where she is not able to return to a home that she owns with her mother. He is not on the mortgage. She's on the mortgage. Her mom is on the mortgage. So we would ask certainly that the stay away not be issued for those reasons. Also, we'll be asking for a signature bond. As you heard, she only has, it's my understanding, 1 prior conviction. There's an open battery case. From my understanding, speaking to Ms. Duffy, I do not represent her on that case, but that case was in a position to be dismissed. Also, Your Honor, it's my understanding that with respect to this, Ms. Duffy called the officers. So again, we vehemently deny the allegations that are in the affidavit. She has significant ties to the community. As I already stated, she has this home that she shared with her mother. She is currently a student at Regents University. She does not have any income at this time, where she, previous to this, she was doing DoorDash, Instacart, a lot of gig work to make ends meet. But because of this case, she's no longer able to do that. She's been removed from the platform, from my understanding. Based on her lack of history, based on the nature of the charges, and based on her, the fact that she does care for 2 minors, a 5-year-old and a 1-year-old, and her current financial position, which again, she's relying on student loans to make ends meet. And also, again, she shares a home with her mother. We'd be asking for a signature bond. If Your Honor is not amenable to a signature bond, we would ask for a bond of no more than $500. Again, she just does not have the financial wherewithal to meet a $5,000 bond.
All right. Defendant will receive a $2,000 surety bond, $1,000 on the battery, family violence, and $500 on each count of cruelty. She's to have no contact whatsoever with Mr. Smith. She's to stay away from the address on Laurel Ridge if the victim is in fact residing there. She can return one time with law enforcement to make that determination. If the victim is not there, The stay away will not apply. She's arranged transport of the children by coordinating that effort with a third party. Is there anything further from either party?
Nothing further from the state, Your Honor.
There's nothing further from me, Your Honor.
All right. Best of luck to you, Ms. Duffy. That concludes your hearing at this time. So do we have
Judge, what was her total bond?
2,000?
Good bond?
Yes.
Thank you. Position 11, Hill.
All right. Good afternoon, Mr. Hill. Your case.
Hill, where's Hill? Hold
Is
on,
he
Judge, sorry.
Your Honor, if I may, so this case, Mr. Hill, he's a co-defendant with two other individuals that are also on the calendar, and we would ask that they be back to back, just because the facts are the same.
This is gonna be position 12, Kendrick.
All right. All right, Mr. Kendrick, good afternoon. Your case is 23 CR 0000782H. In this case, you're charged with battery family violence with the offense date of November the 11th of 2022. You understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard?
This fourth arrest, last was 2021 battery DV. That was non-process. Before that was 2018 forgery in the third degree. It was amended to disorderly conduct conviction. And 2010 theft by taking, criminal damage to property, second degree, and burglary. The theft was dismissed. The criminal damage and the burglary he got first offender for. That's it.
All right, thank you. Whose case is this for the state? Is it Ms. Dillingham? No one wants to claim this case for the state?
Your Honor, which case is this?
Position 12, Mr. Kendrick.
I'm sorry, I thought this was
Actually, a
position
conflict.
11.
No, this
No,
is
it's a conflict, but we still need the state. So is it yours, Mr. Abdullah?
Yes, this is position 12.
Yes, please proceed.
I'm sorry, I thought they called position 11.
All right, please proceed.
Your Honor, the facts show that on November 11th, 2022, the victim, Miss Alexis Dawson, called 911 to report an assault. Miss Dawson told officers that she was slapped and punched in her face by her husband during a verbal dispute. Officers clearly observed a scratch above Miss Donaldson's left eye. While officers were on the scene, Miss Donaldson called the defendant, and after speaking to him for a few minutes, Miss Donaldson immediately became uncooperative with officers. Miss Donaldson only gave the defendant's name and refused to tell the officers anything else about the defendant. One of the officers on the scene noticed Miss Donaldson from a previous family violence case where both the defendant and the victim were arrested. Miss Donaldson confirmed that the defendant was the same person that was arrested in the previous case. As you heard, the defendant was arrested for battery family violence in 2021 against the same victim in this case. For that reason, as well as the fact that the victim became uncooperative after speaking to the defendant, the state is very concerned that the defendant may have influence over the victim and may influence or intimidate her not to cooperate with the prosecution of this case. For that reason, the state is recommending a $4,000 surety bond, no further contact with the victim, a stay away from the incident location, 3787 MLK Drive, no weapons, drugs, or alcohol while on bond, and 1 day anger awareness. If we could sound for the victim.
And is it Donaldson or Dawson?
Donaldson, I'm sorry, Your Honor.
All right, I'm sounding for Ms. Donaldson at this time. If you're present on the Zoom conference and wish to make a statement. All right, hearing and seeing none, Ms. Watson Cafe.
Yes, thank you, Your Honor. We would be asking for a signature bond, but if Your Honor is not amendable, we would be asking for no more than a $500 surety bond in this case. Mr. Kendrick has been here in Georgia for 12 years. He has strong ties to the community. He's gainfully employed, where at the time of his arrest, he was gainfully employed. We're not sure at this moment right now whether or not he's going to still be employed at that location due to this arrest. He has two minor children who he provides for both financially and emotionally, a 4-year-old and a 6-year-old. As Your Honor heard, the prior battery that he was arrested on was actually dismissed. We don't have any reason to believe that the state was able to move forward on that case. The 2018 was a disorderly, and then in 2010, which was quite some time ago, was done under first offender. So assuming that he successfully completed that, that wouldn't have resulted in a conviction either. So based on all of the above, we believe that a signature bond would be sufficient in this case. Your Honor, any concerns that the state may have can be addressed through conditions, a stay away order. They do not reside together. I have an address here on Middleton Road for Mr. Kendrick. You know, other than that, Your Honor, again, based on the fact that we're unsure on whether or not he still has employment, we would argue that he does not have a significant history, and his strong ties to the community, would ask that Your Honor grant him a signature bond or a bond of more than $500.
All right. At this time, defendant will receive a $2,500 surety bond. He's to have no contact with the alleged victim, last name Donaldson, and stay away from the address on MLK Junior Drive. Additionally, he's to have no alcohol, drugs, or weapons as a condition of this bond. Is there anything further?
I do not have anything further, Your Honor. Thank you.
All right. Best of luck to you, Mr. Kendrick. Who do we have next?
Position 11, Hill.
All right, and this is the case with the co-defendants. All right, Mr. Hill, your case is 23 CR 0000788G. You're charged with criminal trespass with the offense date of February the 6th. Do you understand your rights?
Yes.
All right, Mr. Howard, can I have his history?
I do not want to interrupt, but I have to, Your Honor. I believe we could not find another conflict of attorney for him, so he has to either go as a pro se or wait until tomorrow.
Okay. Mr. Hill, I've been informed that there is no conflict attorney available to assist you today with this proceeding. What will happen is I'm going to listen to the arguments made by the state. If I do not feel that you can receive a signature bond at this time, I will still issue you a bond, and then I will reset your case to tomorrow's SCA calendar in the hopes that wait. Let me finish explaining. And then what I will do is I'll reset the case for tomorrow in the hopes that the conflict attorney will appear. I will hear from you very limited questions about your bond, but I do not want you to speak to the nature of what happened because the state is listening, okay? So we're gonna move forward with your hearing as if you had an attorney. And if you don't receive a signature bond today, you will appear again on this calendar tomorrow. All right, Mr. Howard, can you please proceed?
17 total. Last arrest was back in May, probation violation, ag assault. That case number 19 SC 169513. 2019, they gave him 10 years probation for that. On probation out of state court, trespass. 22 CR 001-929Y. They gave him 12 months probation for that back in April. He has a 2015 battery conviction. 2017 failure to appear. I'll get that. That's it.
Okay, thank you. Ms. Dillingham.
Yes, Your Honor. This incident occurred February 6, 2023. Officers responded to 719 Penn Avenue Northeast, which is a vacant home under construction owned by a man named Brian Pruitt. There, the officers learned that the defendant, along with his co-defendants, entered the home by climbing through the window. We did speak with the homeowner, Mr. Pruitt, who stated that there was no damage to the home and that nothing was taken, but he wants to make sure that the defendants do not come near his property again. And so for that reason, the state is recommending a $3,000 signature bond through pretrial services and a stay away order from 719 Penn Avenue Northeast.
All right, I see Mr. Pruitt is on the line. Mr. Pruitt, do you wish to make a statement today? Okay, hearing and seeing none.
I'm sorry, Your Honor, I had some technical difficulties. I have nothing to add.
All right, thank you, Mr. Pruitt. I appreciate you coming to court today.
Yes, ma'am. Thank you.
All right, Mr. Hill, I'm gonna grant the the state has indicated that they are recommending that you receive a signature bond as long as you understand that you absolutely cannot return to that address. Do you understand that, Mr. Hill?
Yes, yes.
All right, I do not want you to say anything else. Do you have any other questions regarding the bond?
No.
Your
All
Honor,
right,
Your Honor, if I may, my sincerest apologies. Another condition for that signature bond we wanted to request was no further contact with either.
I was gonna order that as well. All right, defendant will receive a $5,000 signature bond through the jail. He is to have no further contact whatsoever with Mr. Pruitt, whether through social media, phone, or by going to that address. And he additionally must stay away at least 1,000 yards. That means don't even go down that block, Mr. Hill, from 719 Penn Avenue. You understand that?
Yes.
Don't even look at that street. Go the other direction. This is a second chance for you, Mr. Hill, okay?
Yes, ma'am.
All right, that concludes your hearing at this time. All right, who do we have next?
Position 2, Brodus.
Is this the co-defendant?
No, Your Honor, the other co-defendants are position 7 and position 10.
Can we do those positions, the co-defendant?
7 and 10. Okay, go ahead and have it. Position 7, Fraction.
All right, Mr. Fraction, your case is 23 CR 0000786G. You're charged with criminal trespass with the offense date of February the 6th. You understand your rights?
Yes.
All right, Mr. Howard, can I have this history?
Yeah, 25 total. He's on probation for added assault, 19 SC 173677. He should get off of probation for that in August. Hold on. He got history from out of state. I got an Indiana 2014 battery, 2012 FTA, 2012 disorderly conduct.
Okay, that's sufficient.
Well,
Ms.
he got other
Dillingham?
states too, though, just so you know.
Okay, that's sufficient. Ms. Dillingham?
Yes, Your Honor, the facts in this case are the same. Would you like me to repeat them?
No.
Okay.
Just
so
your
the state-
recommendation.
The state's recommendation is also a $3,000 signature through pretrial services, a stay away order from 719 Penn Avenue, no further contact with Brian Pruitt, and no further contact with either defendant, either co-defendant.
Okay. And who represents this defendant? Is you, Ms. Holly?
That's correct, Judge. Yes,
And you have any objection to that? I'm inclined to grant that.
no objection to the signature bond.
All right. I do need to amend the previous defendant's order to include that having no contact with the co-defendants, Ms. Bridgewater. So as in the last case, defendant will receive a $5,000 signature bond through the jail. He's to have absolutely no contact with any of the co-defendants or Mr. Brian Pruitt. He's to stay away from the address on Penn Avenue at least 1,000 yards. Don't go down that street, just as I indicated before. And furthermore, to have no alcohol, drugs, or weapons as a condition. Is there anything further? All right, best of luck to you, Mr. Fraction. Do not go back to that address under any circumstances. You understand that?
Yes, ma'am.
All right, best of luck to you. Who do we have next?
Quick announcement for position 10, they waived their appearance.
Okay. Is that the co-defendant?
That was the other co-defendant, Mr. Green.
Okay, so we'll do that one at the end of the calendar.
This is.
Oh, and I represent that. That's Mr. Green. I represent him. Your Honor.
Oh, so he didn't waive his appearance. He's here?
He
No.
did waive his appearance. He had some medical issues. I hope they brought him to medical. I'm not really sure, but he was having some medical issues when I was speaking to him. Physical, not mental.
Okay. So this is Mr. Green that's sitting in the chair?
No, this is a new position. This is gonna be position 2. Brodus.
Okay. Okay, so let's quickly, we're gonna take Mr. Green at the end of the calendar then. Who's sitting in the chair? And I'll just make a note about that one.
Position 2, Brodus.
All right. All right, Mr. Broders, your case is 23 CR 0000793E. You're charged with simple assault with the offense date of September the 4th of 2021. Do you understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard, can I have the history?
6 total. He got history in Pennsylvania and Georgia. As far as the Georgia history, 2014 probation for suspended license, 2013, same thing. Got a 2018 arrest out of Pennsylvania. It says Cosmetic Drug Act. 2018 simple assault, aggravated assault as well. Looks like those were dismissed. That's pretty much it.
All right, thank you. Ms. Dillingham?
Yes, Your Honor. On September 4th, 2021, officers responded to the KED Plasma located at 6445 Old National Highway. There they learned that the defendant got into a verbal argument with the victim, Jovan Burton, who is one of the employees at KED Plasma. The argument escalated to the defendant stating that he would go get his gun and pistol whip Mr. Burton. And then the defendant was asked to leave immediately, to which he yelled, "I'm coming back with my gun." Your Honor, the state does believe that the defendant poses a danger to the community, as this was completely unprovoked. And due to the aggressive and violent nature of the defendant's actions and threats, the state is recommending a $2,000 surety bond, a stay away order from that address, 6445 Old National Highway, and no further contact with Jovan Burton.
All right, I'm assuming Mr. Burton is not on the Zoom conference, but Mr. Burton, if you are present and would like to make a statement, this is your opportunity to do so. All right, hearing none, Ms. Holly.
Yes, Judge. Mr. Burtis is 30 years old. He has been in the state of Georgia for about 4 years, and he does have a job at a hotel where he works in internal logistics. He's had that job for about 4 months. This is fairly old for him to have just been arrested on that. And I would like to point out that this was September of 2021, which is over a year and a half ago now. He also denies having a gun or alleging that he had one at any point. We would ask for a signature bond on this case. He has not had contact with the law since this incident, and I think that that shows his that this incident may not be as it seems.
All right, defendant will receive $1,000 surety bond. He's to stay away from the address on Old National Highway, have no contact with Mr. Burton, and have absolutely no drugs, alcohol, or weapons. Anything further?
Nothing further from the state.
All right, best of luck to you, sir. Who do we have next?
Judge Williams, I have a quick announcement. Do we have a Spanish interpreter?
No, we don't have a Spanish.
I don't, we do
interpreter.
not.
I didn't think there was a need for that.
What position 5 needs an interpreter?
Correct.
And no, and I'm assuming no member of the public defender's office has interviewed him then.
I have interviewed him. I speak Spanish. I'm not a certified translator, though.
Right, right, I understand. Okay. I doubt we'll be able to get one. Miss Champion, if you're listening, will you see if we can perhaps get an interpreter on the line and
Yes,
take
ma'am.
that case at the end?
I'll check and see if we can get one.
All right, I know that that's not likely, but let us still try. All
Okay.
right, who do we have next?
Position 15, Signer.
All right, good afternoon, Mr. Tickner. Your case is 23 CR 0000790G. In this case, you're charged with possession of marijuana less than an ounce, a seatbelt violation, public drunkenness, and willful obstruction, each with the offense dates of February the 7th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have his history?
20 total. Last was 2017, probation for entering vehicle. He was convicted for entering auto in 2018. 2017, possession of a firearm by a convicted felon or felony first offender, 2 counts. That was a conviction. 2016, false report of a crime, burglary in the 2nd degree conviction. He might still be on probation for that. What else? 2008 entering auto. So
That's
everything else is
sufficient.
before that.
Yeah, that's sufficient. Thank you. Mr. Abdullah?
Yes, Your Honor, the facts show that while patrolling the area of Joseph E. Laurie and Fair Street, the officer noticed the defendant driving without a seatbelt. The officer activated his lights and pulled the defendant over on Parsons Street, at which time the defendant stopped in the middle of the road and placed his hands out of the window. But before the officer could get out of his vehicle, the defendant drove off for a short distance and then stopped again, at which time the defendant jumped out of the car and stood in the middle of the road. He refused the officer telling him to sit back in his car. Instead, he stood in the middle of the road and began spinning around in the middle of the street. The defendant started to reach behind his back and fumble with his shirt, and then quickly pulled his wallet from his pocket as if he was trying to provoke the officer. The defendant then walked towards the officer, refusing verbal commands to stop, at which time the officers grabbed the defendant by his wrist and placed his hands behind his back. The defendant resisted and refused to put his hands behind his back, but officers were able to cuff him. The officer could smell alcohol on the defendant's breath and also smelled marijuana in the defendant's car. The officers did recover 3.5 grams of marijuana from the defendant's car. The state is recommending, well, before that, this case more than likely should have been a DUI. The officer did note that he was unable to do any field sobriety tests for his safety because of the defendant's actions. The officer had safety concerns and he was alone. His backup didn't respond fast enough before he had to put the defendant in handcuffs, and he was afraid that the defendant could run away if he had tried to do the field sobriety test. So for those reasons, a field sobriety test was not complete, but the defendant was intoxicated while driving. For that reason, the state is recommending $250 surety bond for the marijuana, $250 surety bond for the seatbelt violation, $1,000 surety bond for the public intoxication, $1,000 surety bond for the obstruction, for a total of $2,500, and no alcohol, drugs, or weapons while on bond. Nothing further from the state, Your Honor.
All right, thank you. Ms. Kim?
Yes, Mr. Tigner is 32 years old. He was born and raised here in Georgia. He actually, he's gainfully employed at Power Labor Staffing as an electrician. His highest level of education was 9th grade in high school. After that, he has been working. It seems like he has a parole at Clayton County. So we called a parole officer and we could not reach. So we left a message to make sure that he gets a notice that he is actually in the Fulton County in jail, so he's not in trouble for missing any kind of meeting. We would like to request for a split bond, seatbelt and marijuana. We would like to request for a signature on bond, and also public drunkenness and willful obstruction. We would like to request for a signature on bond. If Your Honor is not inclined to give him a signature on bond, I would like to request for maximum $1,000, $500 for public drunkenness, willful obstruction, $500, and the other two can be signature on bond through jail. Thank you.
All right, defendant will receive a $3,500 split bond, broken down as follows. On the marijuana possession less than an ounce, that'll be a $1,000 signature through the jail. For the seatbelt, it'll be a $1,000 signature through the jail. On the public drunkenness, that'll be a $1,000 surety bond. And on the willful obstruction, that will be a $500 surety bond. That should equal that total $3,500 split. And additionally, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing from the state.
Nothing.
All right. Best of luck to you, Mr. Tigner. Who do we have next?
Position 9, Giles.
All right, good afternoon, Mr. Giles. Your case is 23 CR 0007808. You're charged with simple battery with the offense date of October the 31st. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have that history?
Second arrest. Last was 2018 DUI hit and run.
Okay, thank you. Mr. Abdullah?
Your Honor, the facts show that on October 11, 2022, the victim, Amit Shah, reported to officers that he was in a meeting with the defendant and he suddenly grabbed Mr. Shah by the neck and started to push him to the back of the establishment. As Mr. Shah was leaving, the defendant came outside after him and continued to try to fight him. Officers were able to corroborate Mr. Shah's report with a witness who was present the day of the incident. The witness gave officers an identical report of the altercation between Mr. Shah and the defendant. The witness also told officers that the defendant was intoxicated and very irate. Although the defendant does have a remote criminal history, this case is concerning because it seems as if the defendant is in a managerial role at the location where the victim, Amit Shah, works. So for that reason, it seems as if, or the facts show that Mr. Giles actually insulted an employee that works for him. For that reason, the state is recommending a $2,500 surety bond, no further contact with the victim, Amit Shah, a stay away from the incident location, 110 Peachtree Street, 1 day anger awareness, and no weapons, drugs, or alcohol while on bond. If we could sound for the victim.
Is he alleged to still work at that location? Is the location the 1100 Peachtree Street? That's the place of his employment where he's alleged to be a manager?
Yes,
No,
sir.
no.
I believe, yes, Sean. I believe he's a co-manager. He's one of a few managers at that location. We weren't able to speak to the victim, so we don't have. We didn't get an up-to-date whether or not the victim still works at that location. So for that reason, we're just going to request to stay away from it.
All right. I'm sounding for Mr. Shaw. I do not believe I see him on the line, but in the event Mr. Shaw is here, this is your opportunity to make a statement. All right, hearing and seeing none, Ms. Kim.
Yes, Caleb Giles is 27 years old. Your Honor, he does not work there. It was a bar where he was visiting. He works a part-time at Little Spirit, and also he does condo cleaning with his mother as a self-employment small business. He graduated from high school, and also he has a certificate from trade school for audio engineering. Your Honor, I don't think he has no objection to stay away from that bar, 1100 Peachtree Street, and he has no objection to stay away and no further contact with Mr. Amit Shah because they don't know each other. He doesn't have any incentive to meet him ever again. We would like to request for a signature on bond since this is his first offense, and he has been here in Georgia for more than 6 years. He has a sister, aunt, all here in Georgia. We would like to request for a signature on bond. Thank you.
All right.
Your Honor, if I may, I know that. I'm sorry.
Very quickly, go ahead, Mr. Abdul.
I know that this isn't we're not arguing, whether or not the defendant did or not, but the warrant does state that the victim and the defendant were actually in a meeting at the time of the attack. So there seems to be a confusion as to whether or not they were knowing each other, but this wasn't a violent attack. A random attack according to the warrant.
All right, thank you. Defendant will receive a $2,500 signature bond through pretrial services. He is to take the 1 day anger awareness course. Oh, I'm sorry, that is per judge. He is to have no further contact with alleged victim, last name Shaw, and he is to stay away from the address on Peachtree Street, have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the defendant.
All right, best of luck to you, sir. That concludes your case. Who do we have next?
Position 6, Bicklin.
All right, good afternoon, Mr. Franklin. Your case is 23 CR 0000789H. You're charged with criminal trespass with the offense date of January the 31st. Do you understand your rights?
Yep.
Mr. Howard, can I have the history?
First.
All right, thank you. Ms. Dillingham.
Yes, Your Honor. This incident occurred January 31st, 2023, when officers responded to North Metro G-Nets at 601 Beckwith Street, where the defendant, a student, at that school. There, they learned that the defendant had become very disruptive while being driven home by the school bus driver on the school bus. And upon arrival to her location, the defendant exited the bus and bashed the glass door panel window of the bus, causing it to break. We are aware that the defendant has no priors, and for that reason, the state is going to recommend a $2,000 signature bond through pretrial services. And due to the nature of the crime, which was unprovoked, we are recommending 1-day anger awareness and a curfew from 8 p.m. to 6 a.m. With a cosigner for the bond, as well as a stay away order from the north, from the school location.
And he's still alleged to be enrolled in the school?
From my knowledge, I don't believe the defendant is still enrolled at the school.
All right. Ms. Holly?
Your Honor, Mr. Ficklin is 18 years old. This is the same school as the prior incident, and I don't believe anyone is still on, but I was not aware that he had been removed from the school. And as far as I'm aware, there's no prior incident. So I was told that he's currently in the 12th grade, set to graduate in May, and that he intends to enter the military to become a mechanic and work on planes after his graduation. We have no objection, obviously, to the $2,000 signature bond and anger awareness. The stay away from the school, if he's still enrolled there, obviously we would object to that because that's his ability to graduate. I'm not sure if the court wants to order some type of stay away, perhaps from the bus driver or the bus system, so he may need to find another way to get to school, but other than that.
All right. All right, defendant will receive the $2,000 signature bond through pretrial services. He's to take the 1-day anger awareness course. He is to stay away from the school address if he's not currently enrolled. If he is enrolled in the school, he can return there, but he is not permitted to ride the bus. He will have to find another way to get to school. Additionally, despite his age, he's to have no alcohol, drugs, or weapons. Of course, that applies. Ms. Holly, do you know the name of the cosigner?
I can tell you, please hold. Cosigner will be Alicia Ficklin, same last name, Alicia.
All right.
And I'll give her a call, Mr. Ficklin, to let her know.
All right. All right.
Are you
Thank
waiving?
I will. If you'll send me the waiver, I will sign. That concludes your hearing, Mr. Ficklin. Please behave yourself. All right. All right. Who do we have next?
Position 8, Garrett.
All right, and we will have the Spanish interpreter shortly. So let's try to do as many as we can before that. Mr. Garrett, your case is 23 CR 0000791F. In this case, you're charged with battery family violence with the offense date of August 17th. Do you understand your rights?
Yes, ma'am.
Mr. Howard, can I have the history?
25 total. He's on probation for criminal attempt to commit a felony. Possessing the tools for the commission of a crime. What else? Criminal damage to property, 2nd degree. I got a battery DV and theft by taking. He got several burglary and theft convictions in his history. Probation violation.
Okay.
That's pretty much it. Most of his history come out of like Athens or Pony County, out that way.
Okay. Ms. Dillingham?
Yes, Your Honor. This incident occurred August 17th, 2022, where officers responded to 1737 Gibbon Road Southwest, where the victim, Miss Quinteris Brown, and the defendant were living at the time. There they learned that a verbal argument between Miss Brown and the defendant ensued and escalated, to which Miss Brown had asked the defendant to leave. And in response, the defendant became extremely angry and punched Miss Brown multiple times in her face. Officers, upon arrival, observed the significant bruising to Miss Brown's face. And Your Honor, due to the defendant's long history, including over 6 failure to appear, 2 prior battery arrests, and also due to the violent nature of this crime and Miss Brown's significant injuries, we do have a serious risk of reoffense and possible intimidation. And so the state is going to recommend a $3,500 surety bond. We did speak with Ms. Brown, and she stated that she no longer lives at that address, so a stay away from that specific address is not necessary. However, we would definitely request no further contact with her and a stay away from any place that she is, as well as a one-day anger awareness.
All right, I'm sounding for Ms. Brown at this time. Ms. Brown, if you're present, this is your opportunity to speak. All right, hearing none. Ms. Holly, is this your client?
Yes, Your Honor. Understanding the defendant's criminal history, I'd like to explain a little bit his status in the jail right now. So Mr. Garrett was actually brought in Clark County on a probation violation in October, and he has been in custody since October. He pled into drug court in Athens, Clark County on Monday and was meant to be released to go to the Just Stay Sober 6 to 12 month drug court program on yesterday, but when he went to be released, he was informed of this warrant. I did speak with Just Stay Sober. They confirmed that he is expected there and that the program has a mandatory 6 month, but as long as 12 months, depending on what drug court directs him to do. I do believe his involvement in drug court. I am familiar with drug court. It's a very intensive program. It's constant checking in, and he will have an officer assigned to him. It'll be a part of his probation. I think that that should quell any fears of failure to appear. With that being said, I do believe that there is a substance abuse history that does explain some of that. And obviously, Mr. Garrett is ready to make that change because he has agreed to enter into drug court. With that being said, due to the amount of time he's been in addition to the fact that he was supposed to already be at the sober living house, we would ask for a signature bond just so that he can go back to Clark and be transported directly from there. There is no time that he would be released. He will be transported directly from Athens, Clark to the sober living home. They have a transport ready as soon as he's back.
All right, and Ms. Holly, you have proof that he's or something?
I spoke with the sober living house.
Okay. All right, Ms. Dillingham, you unmuted. I'm assuming you'd like to weigh in.
If I could maybe get that documentation regarding his transportation to the sober house.
I can give you the number of Tim, who I spoke with, who's the director of the sober living house.
If you could send that to me in the chat.
All right. Based upon Ms. Holly's representation that he's going to a sober living home and enrolled in drug court, and as a member of the court, she makes those statements. Defendant will receive a $5,000 signature bond. I'm trying to figure out if I send it through the jail, he will still be released to the. He'll be released to the Clark County hold, Ms. Holly?
Clark County has a hold. I don't know if someone from the court can confirm that, but my understanding was
that's what I want to confirm. Can we confirm that? Because I don't want him to just get out. I don't have any. The court wants him to go to that sober living program if that's in fact where he's going. Ms. Falk?
What is the defendant's last name, Your Honor? Is this Mr.
Garrett?
Garrett. Okay. And Your Honor, I actually unmuted just to say that if possible, one of the things that we can do is make it a condition that he has to be in the sober living house within 30 days. And so that way, if he fails to comply, we would be able to revoke his bond.
All right.
We don't have any objection to that.
All right. So
he don't have no warrant.
He does not?
No.
Well, I'm seeing foreign county hold.
Yeah, that's what I saw.
What, on the booking
jail
sheet?
screen? Yeah, in the jail screen.
Yeah, I'm looking at the GCIC. It says no, hold on.
Well,
no NCIC warrant.
Well, what we can still do is we can give him the signature bond, and as Ms. Falk has indicated, he has to report there within 30 days.
Okay, you just have to report that.
And we don't have an objection to any of the no further contacts.
Right, and no further contact, stay away from the incident location.
She's gonna give you a signature.
All right?
Okay, ma'am.
Judge,
All right.
Jail?
Through the jail. Is there anything further?
Nothing further from the state, Your Honor.
All right, best of luck to you, Mr. Garrett. If you have a question, the best thing to do is to ask Ms. Holly, but I will hear a very, very limited question. What's your question?
I really didn't have a question. I was just gonna make a statement. Well, that's okay. I'll just wait.
No, don't do that. That's not a good thing to do, okay?
Thank you, ma'am.
All right, take care. We now have the interpreter on the line, so if we could go back to position 5.
Good afternoon, Your Honors.
Good afternoon. Ma'am, will you please state your name for the record?
Yes, Your Honor. My name is Jatu Tolles, Jartu, last name Tolles.
And pronounce your last name for me again. It's Ms. Tolles?
Tolles, yes, ma'am.
Yes, Ms. Tolles, please raise your right hand. Do you swear and affirm that today you will make an accurate translation from Spanish to English, English to Spanish to the best of your skill, knowledge, and ability?
I do, Your Honor.
All right, thank you. You can put your hand down. All right, we will now take up the case of Jose Enriquez, case 23 CR 0000781B.
Ahora estamos conociendo el caso del señor José Enríquez, número de causa 23CR000781B.
In this case, you're charged with criminal trespass and theft by shoplifting.
En este caso, señor, se le imputen las infracciones de invadir una propiedad privada y también hurto en tiendas.
With the offense date of February the 7th.
La fecha de la infracción es el 7 de febrero.
Okay. You have an absolute right to remain silent. Anything you say can and will be used against you.
Señor, usted tiene todo el derecho de permanecer callado. Cualquier cosa que diga se puede y se usará en su contra.
You have a right to an attorney.
Tiene derecho a un abogado.
And this proceeding is being broadcast over the internet.
Y esta audiencia se está transmitiendo por internet.
That means any member of the public can log on and watch.
Eso significa, señor, que cualquier miembro del público puede iniciar sesión y mirar la audiencia.
Do you understand your rights and how I'm conducting this proceeding today?
¿Entiende, señor, sus derechos y la manera que estamos llevando a cabo esta audiencia?
Do you understand your rights?
¿Entiende sus derechos? Your Honor, the interpreter is not hearing your response. May I make sure if he can hear me?
Can he hear us?
Señor, ¿nos está oyendo? ¿Me puede oír? Can you hear me, Your Honor?
I can.
I think they're froze.
Yeah, I think courtroom 2 just froze. Well. Okay, courtroom 2 is back. Will you please, Madam Interpreter, will you please ask if he heard his rights and understood them?
Señor, ¿escuchó los derechos que le acabo de explicar y los entendió? Your Honor, are they frozen again?
I think so. This is very difficult.
But I'll give you the history real quick though.
He's got to hear it, so that won't save us.
But I know she's gonna translate it. That's what I was saying. I was gonna run to the restaurant real quick.
All right, Mr. Howard.
All you got is this is second arrest.
Oh, wait, hold on. He's back. Do you understand your rights?
Señor, ¿usted entendió sus derechos? Yes.
Thank you. All right, Mr. Howard, please proceed.
Second arrest, 2011, driving without a valid license conviction. That's all.
Licenciado Howard, ¿cuáles son los antecedentes? Este es la segunda vez que está detenido. Lo arrestaron en 2011 por manejar sin licencia válida. Es lo único que tiene de antecedentes.
All right. Ms. Dillingham, please proceed with your recommendation.
Yes, Your Honor. This incident occurred February 7th, 2023, yesterday.
Licenciada Dillingham, ¿cuál es su recomendación, señora fiscal? Sí, este incidente ocurrió el 7 de febrero, ayer mismo.
When officers responded to Walmart at 970 Mansell Road.
Cuando los agentes de policía acudieron al 970 de la Mansell Road, el Walmart.
There, they learned the defendant entered and remained at the Walmart after previously receiving a criminal trespass warning from the Walmart.
Ahí supieron que el señor acusado ingresó y permaneció dentro de la tienda Walmart después de haber recibido una advertencia de invasión a propiedad privada anteriormente.
And the defendant stole a bottle of Coke, a red bandana, and a deodorant stick.
Y el señor acusado se robó una botella de Coca-Cola, un pañuelo rojo y una pastilla de desodorante.
Due to the lack of violent history, the state is recommending a $3,000 signature bond through pretrial services.
Como le falta antecedentes penales violentos, el Estado está recomendando una fianza de $3,000 bajo palabra a través de servicios previos al juicio.
That's $1,500 each count and a stay away order from the Walmart at 970 Mansell Road.
Sería $1,500 de fianza para cada infracción y una orden de ningún contacto con la Walmart que está sobre el 970 de la Mansell Road, que no vaya más. Okay.
All right, Ms. Holly?
Yes, Your Honor. I don't have an objection to the $3,000 signature bond.
Licenciada Holly, de la defensa, sí, su señoría, yo no me opongo a la fianza de $3,000, la fianza bajo palabra.
All right, at this time, I'll accept the state's recommendation and defendant will receive the $3,000 signature bond through pretrial.
Muy bien, en ese momento yo acepto la recomendación del Estado y le impongo al señor acusado la fianza de $3,000. Es una fianza bajo palabra que se tramitará a través de la Oficina de Servicios previo al juicio.
That will be $1,500 each count.
Sería $1,500 para cada infracción.
And defendant must stay away from the Walmart on Mansell Road.
Y que no vaya más el señor acusado a la Walmart que está sobre la Mansell Road.
And have no alcohol, drugs, or weapons.
Que tampoco esté en posesión o que no consume alcohol ni droga ni esté en posesión de armas.
Is there anything further from either party?
Is that through the jail?
Algo
No,
más que
through
tratar.
pretrial.
Pretrial, thank you.
Es una fianza a través de la cárcel, no a través de la Oficina de Servicios previos al juicio.
And nothing further from state or defense?
No, Judge.
Nothing further from the state.
Nada más del Estado ni de la defensa, no, su señoría.
All right, that concludes your case, Mr. Enriquez.
Muy bien, señor Enriquez, está concluido su caso.
All right. Madam Interpreter, will you please sound for anyone else that may need your assistance?
Certainly. ¿Hay alguien más en la sala o que está conectado a la sesión que necesita un intérprete de español? Si me puede dejar saber.
All right, hearing none.
Oh, I think someone is coming in.
Oh, someone else needs your assistance? No,
Señor
that's
Stanley.
Mr.
Listen, you do. Finito.
All right. All right, Madam Interpreter, you can be excused. Thank you for coming on at such short notice.
Thank you. Everyone have a great day.
All right, take care. All right, who do we have next?
This is add-on one, add-on one, Mr. James.
All right, Mr. James, your case is 23 CR 000783A. I do not have the charges, so I will have to rely on Mr. Abdullah for those. You understand your rights today?
Yes, ma'am.
All right, Mr. Howard, do you have his history?
I do not.
All right, Mr. Abdullah, we'll have to rely on you for history and the offenses with defendant is charged.
No worry, I have it for you. So the charges on this case are battery, family violence, and criminal trespass.
Okay,
Would
and
you
the
like
history?
The history. He has 2 convictions, battery, family violence from 2020, cruelty to children, 2020. And then he has a simple battery arrest from 2021, a criminal trespass from 2014, and an obstructing person making 911 call from 2014 as well.
Thank you, Mr. Abdullah. Please proceed.
Yes, Your Honor. The facts show that on February the 2nd, 2023, officers responded to 105 Anna Avenue for a fight call. They met with the victim, Ashley Lee, on the scene, and she told them the defendant hit her in the face during an argument about a car she purchased for him. Miss Lee was bleeding above her left eye, and officers observed a broken mirror that the defendant broke by pushing Miss Lee into it. The defendant left the scene before officers arrived. However, a few days after the incident, officers returned to do a follow-up investigation to make sure that there was no kids present during the attack, and the defendant was there and arrested on the scene. This case is concerning for the state because the defendant has a history of abusing those close to him. The 2020 conviction for battery family violence was a case in which he assaulted the same victim in the presence of their children. In addition to the 2020 family battery conviction, he also has a simple battery arrest in which he assaulted his stepfather. In addition to that, there's a arrest where he obstructed a person from calling 911. In addition to that, that just talks to his risk of reoffending. But in addition to that, there seems to be, he seems to have an influence over Miss Lee. She told officers while on the scene that she knows that the defendant needs help, but she was very hesitant in saying that she wanted to press charges. More than likely, that's due to the influence that the defendant has over her. The state is concerned that if he's allowed to have contact with her in the future, he could influence or intimidate her not to cooperate with the prosecution of this case. For that reason, the state is recommending a $7,000 surety bond for the family violence, a $500 surety bond for the criminal trespass, and no further contact with the victim, a stay away from the incident location, and no weapons, drugs, or alcohol while on bond. At this time, if we could call for the victim.
All right. I'm sounding for Miss Lee. Miss Lee, are you present on the Zoom conference?
Yes, ma'am.
Would you like to make a statement?
Well, for one, he has no influence.
Wait. Before you tell me anything else, yes or no? Because I would need to place you under oath.
What was the question again? I'm sorry.
Do you want to say something? If you want to say
Yes,
something to
ma'am.
me, all right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right, what would you like to tell the court at this time?
For one, he has no influence over me, Your Honor. Yeah, he made a mistake, and I know he feels very bad for what he did. But me and my kids want their father home, and so do I.
All right, thank you. I appreciate you coming to court to make that statement. Ms. Kim?
Yes,
Your
Your
Honor.
Honor. Mr. James is 34 years old, and indeed, they are engaged right now. It is common law marriage situation, and legally, Mr. James is a single. They have been living together for about 6 years at Mr. James' mother's place with his mother together. They have 2 children, 4 and 5 years old. And Mr. James has been working as an HVAC technician for last 6 months. However, before that, he was unemployed. And also his highest level of education was 10th grade. And he's actually making not enough money at this point. So he's qualified for public defender's services. Miss Lee, Ashley Lee, she is a full-time stay-home mom. So they need my client has to get out of the jail to continuously work so that he can provide to those 2 children and his fiance. We would like to request for signature on bond since this is but however, we do understand that there was history on 2020 if Your Honor is not inclined to give you a signature on bond, we would like to keep that current a surety bond, $5,236 that is already set and placed. Instead of increasing it, we would like to keep it. And also, Your Honor, as you heard, complaining witness, Ms. Lee, wants to have a contact. She's not afraid of him and she wants him home. So no further violent contact is requested. Thank you.
I'm sorry, and I will go back to you, Mr. Abdullah. I know you had a question or a concern. What is the breakdown of the current bond? The current bond is $5,000 on the battery family violence. And what is it currently on the criminal trespass?
$236, Your Honor.
Okay, thank you. Mr. Abdullah?
Your Honor, just very briefly, I had a question for the victim.
All right, very briefly, Ms. Lee, reminding you that you are under oath of the state wishes to ask you a question. Go ahead, Mr. Abdullah.
Ms. Lee, in his battery family violence case from 2020, were you the victim? Have you been victimized before by the defendant? I'm sorry, I didn't hear a response.
Yes, sir.
Oh, okay. And were the children present at that time?
They were there, but they did not see it. They were asleep.
Okay. All right, Jan. I just asked this question. I just wanted to just raise the concern in the state that they do have children. They do have children, and it's concerning that there's already been a family violence case in the presence of the children. There was a cruelty to children conviction. So we just wanted to just restate that there's a risk of reoffending, and ask again that you grant the $7,000 surety bond and the $500 for the criminal trespass case.
All right, thank you, Ms. Kim. Any follow-up or response?
Nothing further, Your Honor.
All right, defendant will receive a $6,000 surety bond, $5,000 on the battery family violence, $1,000 on the criminal trespass. He's to have no further contact with the alleged victim, last name Lee, and stay away from the incident location. He can return one time with a member of law enforcement to get any items. Additionally, he's to have no alcohol, drugs, or weapons. And again, as a reminder, his case will be reset to the state all-purpose calendar on February the 21st, whereby contact and this bond can be revisited at this time. Is there anything further from anyone else? All right, best of luck to you, sir. That concludes your case.
Position 1, Benz.
All right, good afternoon, Mr. Benz. Your case is 23 CR 000-779J. You're charged with criminal trespass with the offense date of February the 7th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have history?
32 total. He got an open felony theft by shoplifting, 22 CP. Well, they put too many numbers on there. I got burglary, second degree, theft by taking, trespass. That's 22 SC 181742. He's on probation for that. They gave him 4 years probation for that back in August 2022. Let's see. Last arrest was November 2021 for criminal trespass. 2020 obstruction, simple battery. 2019 that was dismissed. 2019 trespass arrest. 2018 trespass arrest. 2017 you got time served. That was conviction. 2017 trespass conviction.
I think that's sufficient. Thank you, Ms. Howard. Ms. Dillingham?
Yes, Your Honor. This incident occurred yesterday, February 7th, when officers responded to the Food Mart gas station at 374 Cleveland Avenue Southwest, where they learned that the defendant was on the property after being asked to leave multiple times by the manager of the Food Mart. Defendant was also previously issued a written criminal trespass warning from the manager a few months prior. And Your Honor, as Mr. Howard mentioned, the defendant did commit this crime while on probation. That was ordered December 12th, 2022. And one of those conditions was not to commit any crimes during that 4 years probation. So for that reason, the state is recommending a $1,500 surety bond, a stay away order from the Food Mart gas station at 374 Cleveland Avenue Southwest.
I'm sorry, I didn't catch that amount, Ms. Dillingham.
A $1,500 surety bond, Your Honor.
All right, thank you. Ms. Holly?
So first of all, Your Honor, I'd like to point out that the felony theft by shoplifting that court services is saying is open. I tried to look that case up, and as far as I can see, Mr. Benz does not have any open cases other than this one, and that case number does not open anything in Odyssey. So I'm not sure if that is a mistype or a missearch, but I'm not seeing anything. In addition, this is not a violent encounter, and I'm not sure at what date he was priorly criminally trespassed. I believe what ASG Dillingham just said was that the store's owner had previously criminally trespassed him. I'm not sure if police were involved in that, but a prior criminal trespass warning can't be issued just by the owner. It has to be issued by a police officer or law enforcement of some type. Mr. Benz was simply on the property. He does have a part-time job at another food mart that is up the road where he works off and on when he can. He does not have a significant amount of money, and he certainly can't pay any type of bond. We would ask for a bond and a stay away that is officially written for this location until we can sort if he had been properly trespassed prior.
All right, thank you. At this time, Mr. Benz is going to receive a $2,000 signature bond through the jail. He's to stay away from the address on Cleveland Avenue and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the state.
All right, best of luck to you, Mr. Benz. That will conclude your case. All right, who do we have next?
I'm sorry, Judge, I stepped away with the bond.
It's 2,000 signature through the jail.
Thank you. And also position 10, waive their appearance, and we're completed here in courtroom 2, Judge.
All right, thank you. Have a good afternoon, courtroom 2. This is the case of James Green. We're going to do 23 CR 000787G. He's the companion case to the individuals we discussed earlier. Ms. Dillingham, is this still your case?
Yes.
All right, and I'm assuming you will make similar recommendations?
The same recommendation, Your Honor.
All right, I will do exactly what I did for the others, but Mr. Howard, will you please put the history onto the record?
Sure. 11 total. He's on probation in Douglasville out of terrorist threats. Riot in a penal institution. He was arrested last in March 2022, failed to appear. 2019 probation violation. 2018 probation. He had another 2019 terrorist threats too.
Okay.
Yeah.
And Ms. Watson Cafe, any objection to the signature bond?
I'm sorry, Your Honor, no objection.
All right, defendant will receive a $5,000 signature bond through the jail. He's to have no contact with any of the cross defendants or Mr. Brian Pruitt. Additionally, he's to stay away from the address at 719 Penn Avenue at least 1,000 yards, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the state, Your Honor.
Nothing further from the defense. And that was my last case, Your Honor. May I be excused for today?
You may. We've reached the end of the calendar. Ms.
Oh.
Bridgewater, Ms. Bridgewater, will you please review it for me? Ms. Watson Cafe, take care.
Thank you, Your Honor.
Absolutely. Once again, the reset date for the SAP calendar is going to be February the 21st. Position number 1 is reset further notice with a $2,000 SOB through the jail. Position 2 is going to the SAP calendar with the $1,000 good bond. Position 3 going to the SAP calendar with the $4,000 total split bond. Position 4, SAP calendar with a total $2,000 good bond. Position 5, reset further notice with a $3,000 SOB through pretrial. Position 6, reset further notice with a $2,000 SOB through pretrial per judge. Position 7, reset further notice with a $5,000 SOB through the jail. Position 8, reset further notice with a $5,000 SOB through the jail. Position 9, reset further notice with a $2,500 SOB through pretrial per judge. Position 10, reset further notice with a $5,000 SOB through the jail. Position 11, reset further notice with a $5,000 SOB through the jail. Position 12 is going to the SAP calendar with a $2,500 good bond. Position 13 was null pros. Position 14 is reset further notice with a $3,500 SOB through pretrial per judge. Position 15 is reset SAP with a $3,500 split bond. And the add-on is reset to the SOP calendar with a $6,000 total good bond. Are there any questions, comments, corrections, or otherwise? Okay, well, that's it.
Hearing none, we'll be in recess until tomorrow's SCA calendar. Take care, everyone. Enjoy the rest of your afternoon.
Thank you.
Okay, bye-bye.